I guess it's good afternoon, evening, morning, depending on where you are, or if you are, which planet, which universe. Hello to the pets. Greetings to everyone. This is the third live stream I've done today. Third. I don't think I've ever done 3 live streams in one day. Hello to Dustin. I see Dustin out there, and YouTube user. I love YouTube user. It's a very creative name. So hello, YouTube user and Dustin. And then I see on top of you guys, I see StreamYard. So hello, StreamYard, whoever you are. Anyway, greetings to anybody watching, whenever you're watching. Hope you are all well. This live stream video, whenever you watch it, depending upon, and feel free to ask questions, comments, etc., was kind of related to MMTLP and DJT and stuff that came down yesterday, along with perhaps issues with Gensler, the SEC, maybe testimony, defamation. So there's a whole bunch of stuff I wanted to talk about. Whole bunch of stuff. Before I wanted to talk about that, and before all those humorous jokes, which I try to make, I put humorous in quotation marks. I kind of wanted to just mention one thing. So a lot of times I'll kind of talk about legal stuff, and I might talk about it with too much familiarity. So I think it's common usage and that everybody understands what I'm saying. And that's probably not realistic. So if I use terms that you don't understand, feel free to kick me and let me know. And kind of one thing I wanted to explain is sometimes you'll file a lawsuit, but during the lawsuit, there's a lot of things you have to do before you go to trial. And a lot of that is what litigation is, because most of it is pre-trial, because most cases never go to trial. 95% plus cases don't ever go to trial because they resolve in some fashion, either settlement or whatever. And I know a lot of times, and I've spoken about in terms of Alpine and proceedings before other courts, I use the term stay. And just so I'm clear about what I mean is sometimes someone wants to stop something from going forward, and that is kind of the term. The legal term would be a stay. So someone may want, even though there's a lawsuit pending, they may want to go into court to stay some other thing. So you can have actions within a lawsuit related to the lawsuit, but aren't really about the ultimate, question that's in the lawsuit. So when I use the term stay, that's like somebody going into court on an existing case and trying to stop something. And I'll try to be more explicit when I use legal terms in the future. That just occurred to me the last few days. Anyway, hope that clarifies things. Before I go into this whole bunch of stuff, just to set the mood, avoid temptation unless it's a puppy, obviously. I have jokes about all kinds of sheepdogs. I won't be happy until I've heard them all. My email password has been hacked again. That's the third time I've had to rename my cat. And last but not least, I used to drink like a fish, but I stopped because I kept flopping around on the pavement. Anyway, what caught my attention, besides those brilliant jokes, what caught my attention was, DJT. So I was aware of DJT for quite some time. Whenever it came into existence, I think it was DWAC, it was a SPAC, came into existence as DJT. Obviously, it was an interesting entity, notwithstanding whatever business it did or did not do. And I know there were claims about it being shorted, unlawfully shorted, etc. when it came out back about a year ago. And I know Devin Nunes, who happened to be a House member from California, I believe he was the CEO, and he came out at least trying to pursue clarity about how it was being traded, if it was being shorted, etc. So I remember that. Then all of a sudden it stopped. I think it coincided probably with the election. And there may have been, and again, I'm speculating here, like I speculate on most things, just so we're clear, but I'm speculating it probably did coincide with the election and they wanted to go quiet because it wasn't deemed to be it was problematic to address that issue until you found out how the election went. Anyway, but I'd heard all along that there was interest in them pursuing shorts. And I remember that MMTLP was disclosed to Devin Nunes way back then. And I know personally, I remember hearing about that. And I multiple times, many dozens of times have sent out things to Elon Musk on the same issues because Tesla at some point in time early on was heavily shorted. I think it's probably heavily shorted right now. And a lot of that has to be illicit or could be illicit in my opinion. And I think that he should be interested, and especially in his position at Doge, it gives him an opportunity, obviously, to undertake a lot of investigation that we ordinarily would not have access to. But anyway, getting back to DJT. So I was aware of the fact they were pursuing it, then they stopped because, again, the election, and then I understood they had kind of reignited their pursuit. And I knew they were aware about MMTLP, not only because I was told that, but I remember that occurring. And I also know, I believe they're aware of other tickers, or they were aware of other tickers that had been similarly manipulated, or they thought might have been similarly manipulated. So anyway, I see this, it's dated April 17th. I saw the DJT notice that was sent out to the public on the 17th. And kind of what struck me, because it kind of makes me think about MMTLP. And I know that Nunya, well, I don't know anything because I've never spoken to him, even though we live in the same state. But it's my understanding he kind of understands the facts. And I was aware of this transaction with Cube being QUBE, that they had taken a short position. I thought it was for like 100 million. I think I saw a numerical amount. But the way it's listed here is, and I'm going to use this for those of you that don't know the facts, but I think the issue is DJT thinks it's being manipulated and illegally shorted, etc. And it's calling on an investigation to ascertain if that's been the case. And I remember they referenced that in the past, but here what they referenced specifically is when this transaction happened with Cube and they took their short position, they filed I guess they filed a notice, a disclosure in Germany of their position. And when DJT looked at the short position, let's say, and I'm making up numbers, but let's say April 1, there was 11 million shorts. And on April 15th, this company, Cube, says we just got a 6 million share short position, and they publish that and file it in Germany, but not the United States. And then on April 30th, the short report shows 11 million shares and no reference to the 6 million that were given notice of in Germany. So DJT, this is my understanding, DJT thinks, wow, that's kind of suspicious because why wasn't there a change in the short position? Now, I can answer that question, and I think this was reason number 15 why I thought that FINRA should cease to exist, because in the MMTLP escapades and in the FAQ, they clearly acknowledged when they were calculating the number of short shares, they said, and I don't remember the exact number, but let's say they said, per our, and I'm talking about MMTLP now, they said there's and I'm making up numbers, 2.65 million short shares that we've been able to locate based upon the information. However, once those shares or any short shares leave the confines of the United States, we don't count them. They, in essence, cease to exist. So, and again, I use the example, I put out a tweet. That's funny because it was not related to this, but I put out a tweet and I basically said the way I was. This is my, this was independent of this, so it's kind of funny, but I said independent. Reason number 15 or whatever why FINRA shouldn't exist. Once shares are outside the United States, they don't count them as short, which is the equivalent of, I tried to state, JR, and I'm sure all of you know JR because he's my compadre, and he will be doing a live with me and Curtis on Monday night, 8 Eastern, where we're going to be going over these topics, but I haven't discussed any of this stuff with them. But JR has a pet pig, as you all know, his pet pig named Sammy, and they regularly take vacations to Mexico each year, 3-week vacations. Sounds like wonderful. Sammy is quite a pig. Some say that about JR too, but that might be in a different context. But anyway, but they leave 3 weeks every year, and I was saying the way FINRA operates, where they just kind of, once they're gone, they cease to exist. It would be like when JR and Sammy leave the country to go to Mexico, the census goes and adjusts the U.S. population, the official population, down by 2, which would be ridiculous, but that's what's done by FINRA. And it's absurd that FINRA is provided with the responsibility to protect investors, which comes from the SEC, which is designed to protect the investors. So how could you, if you don't track the share count, how could you possibly be protecting investors? And if you haven't done that, why not? And what do you need? What type of computer software do you need? I know at some point in time, I think it was the SEC, for insider trading, I think they went to Palantir. Palantir created a program for them. This is my understanding. Palantir, which is a software company or a data collection company or AI company, depending on how you want to look at it. They created the software, I think, for the SEC for use in insider trading. And I've been calling for this for quite some time, at least a couple of years. If they need something to be able to track where the shares go, then ask for it, and we shall provide that. If you don't know or cannot do it, then what benefit are you to retail shareholders? And again, your obligation is to protect retail investors. So the fact that DJT, as of April 17th, is basically asserting these short shares that are referenced in Germany aren't reflected in the United States kind of coincides with the way FINRA stated the MMTLP short count, and basically said, we can't tell. We don't follow it. That's not our problem. And that's just an unacceptable answer. And if, in fact, Paul Atkins, I don't think he's been confirmed yet, or he hasn't been put into office. He was confirmed, but I don't think he's been sworn in yet. If he wants to distinguish himself from the prior SEC group, the first thing he has to do is deal with this nonsense about not being able to track shares. How could a market, an efficient market, exist without the ability to track your product at all times? Makes no sense. And it doesn't sound like to me it should be that complicated an issue. Sounds like perhaps maybe it's an issue that somebody doesn't want dealt with, as opposed to an issue that can't be dealt with. So I welcome Paul Atkins when he's confirmed to kind of change the course of enforcement and administration and take the helm. So they complained about that. I know that DJT is aware of the other tickers that have the same issues, including MMTLP, specifically MMTLP, and others that I'm aware of. They also, I think the other complaint was about being on Reg SHO. Okay. So any company that's been heavily shorted it seems to correspond that they also appear on Reg SHO. So those two elements clearly appear in MMTLP and a bunch of other tickers. I think that if in fact they pursue activity to try to eradicate this type of misconduct, I think a lot of tickers will be benefited. And I think, MMTLP should be at the front of the line because of what's been going on. So I find it interesting. The timing is interesting. I am looking forward to see what happens. The one reference that I found amusing was there was a reference, Devin Nunes was referencing, we don't want to be a third world casino, which to me sounds exactly like the end of MMTLP. If that isn't a third world casino, you have your money, you put it down, the casino says, we're just going to take it. Okay, sorry, that's all. And let me address one other point. I know I'm kind of jumping around, but kind of just want to throw out a bunch of points. I think we're going to talk about this on Monday night also. But notwithstanding what the claims are, there's these collateral claims, and I'm going to deal with that in a little later. But there's collateral claims about, the John Berta and George Palikaris, about them doing X, Y, and Z, and I have no idea about that. I wasn't around about that. I've never discussed that with them. So it's not my interest. But I always thought that's a false issue, because my view is, notwithstanding whatever happened prior to December of, I think it's 2022, whatever happened prior to that, so be it. But we came in as is, and we take it as is. And if misconduct occurred while we were shareholders, what happened a year before, whether it be correct or incorrect, doesn't change if the fact that our rights were violated, and doesn't negate that fact. And to the extent that others try to misdirect you into focusing on other issues, doesn't change the fact that in the end, FINRA, with the assistance of the SEC, either intentionally or with their inadequate supervision, screwed retail shareholders. There's no other way of looking at that. And that has nothing to do with what happened years prior, any allegations with regard to John Berta or George Palikaris. Nothing to do. So two separate events. One does not block the second. And FINRA operated on their own. And, if in fact FINRA was acting, just to kind of put this in proper perspective, if FINRA was acting in a manner because they believe that John Berta and George Palikaris had acted in a particular way, and that's why they were acting, they would have said so. They didn't. So now, and they've had, obviously ample opportunity with FAQs, etc. So don't be confused now. And again, I'm not coming down on whether the allegations are true or not, just they're kind of irrelevant to the pursuit of relief based on what happened with the U3 alt. Don't let anybody distract you from that, because that is just a pure distraction. Both could be true. So be it. So anyway, so we have the DJT, and they're moving forward. I think they are moving forward, by the way. They are moving forward. How do I think that's going to result? I don't know. Could there be a short sale ban for a period of time like other countries have done? Very possible. Could there actually be, companies held accountable? That I don't know. Are they going to be they're going to start actions against, and I'm just speculating, because I know that Ken Griffin, I think Devin Nunes didn't get along very well. So is there going to be a legal action against Citadel? Real legal action, not the BS legal action we see. Are there going to be, claims? Are there going to be criminal action, criminal complaints? Because it looks like some of this activity could probably, if in fact the activity that we think occurred, and it could be proven, then it can both be civil and criminal. So are there actors that might have, concerns about their personal freedom? There may be. I don't think we've gotten there, but perhaps with the new the new SEC, perhaps we'll have more disclosure about that. So, but anyway, that's going on. So that's talking about MMTLP. At the same time, as that was going on, there was the release, and I think George Palikaris put out and I don't know how he got access to that. I don't know if that was his FOIA request or somebody else's FOIA request. It's funny because I looked at and I'm referring to MMTLP now, also, just to be clear. I looked at, there's that summary of the FOIA requests that were made. And there's like 600 FOIA requests generating something on the order of over 600,000 pages. And they're only obligated to give you 100 pages, I think, for free, which tells me, first of all, is why isn't there a better system of kind of figuring out or organizing the documents so that they can be easily accessed in an order that we don't have to ask for 600,000 pages to be copied? Because that doesn't really seem like that's a fair way of doing it. There should be some software available that we could pick and choose and not have to be, basically, we don't have access to that information because we can't get the totality of the record. So is that providing you access? No, it's not providing access. And again, I think, again, software could solve that problem. It's probably intentional. You know, my guess is it's intentional. They don't want to solve that problem. But anyway, George Palikaris, I think it was George Palikaris, released documents. I note it was like 56 pages, something like that. I don't know if it's all those documents. I don't know, and there's redactions on it also. So I don't know if the redactions are how they came to him or they were made by him. I don't know who received them. I don't know if this is all the documents for that time period. So let me go back. So Howard originally got those November 21st, December 22nd of 22, and then January of 23. He originally got those documents in that time period. And I think we were led to believe that for that very narrow time period, that those were all the documents. I don't believe that. So for these, you're given like a set of documents and you wonder, are these to kind of confine what your search is to not let you explore beyond it? Or is this all the documents for that time period? I feel very comfortable saying this is not all the documents. And maybe wouldn't be the documents that we would have requested. So again, if there's 600,000 pages and it involves all these subject matters, who's deciding which apply and which don't? And, you know, you're left with, unfortunately, and I think this system sucks, but you're left, if you disagree with the FOIA response and you've done an appeal and they deny it, you got to go and file a lawsuit. And again, you know, who has the money other than JR and Sammy his pig? Who else has the money to go forward and do that? And that's the point. And that excludes the public from having access to documents that exist. I don't understand why there isn't just a database. If this is public information, why isn't there just a database that we as public can go into, have access to? And if there's a cost for actually producing the copies, then we could decide if we want to copy them or not and what the cost is, but do it at a real number, not some BS number, because you could do it for under a penny. There's no reason we shouldn't have access to all these documents, period. It's the law. There really is no reason. And as to the disputed documents, there should be much more scrutiny in terms of the good faith, bad faith objections. And if in fact there are bad faith objections, there should be not only an order providing for the disclosure of FOIA documents, but there should be at least monetary penalties, if not jail. We need to be serious about that to get our regulators and politicians to be serious about it now. And if, like everything else we've seen, is just a slap on the wrist, the response will be weak. And the time will be weak. Anyway, so after that diatribe, so George Palikaris put out some documents, and I kind of like, I looked at them, and I think Curtis, JR, and I will be discussing them in more detail, but just kind of a few of them that caught my attention was, there's documents discussing preparation for meetings, with the senator, and I guess it was Senator J.D. Vance. We don't really know what was discussed at the meeting per se, and this is from Taylor Asher, by the way. I'm looking at a document dated July 17th, Monday, July 17th, from Asher Taylor, who was the policy advisor and confidential assistant to Commissioner Mark, and I don't know how to pronounce his name, so I'm just saying Mark Yu. And I don't know why he was a confidential assistant. What was in a witness protection program? What does that mean? I don't know what that means. But anyway, he's kind of prepping, or he's getting involved. He wants to know kind of what he should be taught, what the topic should be. And one of the topics is MMTLP. So one of them is Ripple, which is XRP, which is a long-standing lawsuit that I think was just resolved or is in the process of being resolved now. One was Coinbase, and Coinbase has been in litigation with the SEC. So if you just go by the first two, this is stuff that was up in front with the SEC because they were involved in litigation, they were aware of it, and it was well known. So if Ripple, and this is from the SEC, from Taylor Asher, the confidential assistant. I wonder, was there a non-confidential assistant? And is there a reason why the assistant has to be confidential? And is he still there? And can he be subpoenaed? Just questions I'm throwing out, by the way. But he refers to MMTLP, so I would suspect that since he's referring to it, and he's a assistant to a commissioner, that it was a well-known concept. Then I saw the letter. This was the interesting one. And I think people have different interpretations of this. So there's a letter dated, one of the documents, a letter dated September 25th, 2023, from the SEC, apparently signed by Gary Gensler, the chairman, to the Honorable Pete Sessions. And Pete Sessions from the House of Representatives out of Texas is my recollection. And it is Gensler, and there was like an interchange, and I think, the House, the gentlemen and the ladies who had signed that letter along with Senator Vance, they were trying to get a follow-up. They're trying to get information, and it was going on, and eventually, I guess, they got a response. It wasn't a great response, in my opinion, but it basically says, and it's from Gensler, and I think the timing is interesting because I believe his testimony before Congress was on September 12th. So he's referring to, MMTLP and the metamaterials Series A staff, and he's referring to the staff providing session staff with a briefing on September 5th on the matters raised in the letter, and that's all the stuff about MMTLP, etc. So people are trying to, I think, extrapolate by that Gensler was in that meeting or briefing, and I don't extrapolate it like that, but I have a kind of different take on that. And the reason why I say this is because I know that, and I'll equate testifying in Congress, it would be like testifying in a deposition. So at a deposition, if you're representing, so a deposition would be a testimony under oath, under penalty of perjury, and there's a transcript and a court reporter, and it's written down. And I think testimony before Congress is very much the same. You're under penalty of perjury, but also, even if you're not under penalty of perjury, if you lie to Congress, it's a felony, but it's pretty equivalent. So if I have a client and they're going to testify, they're going to be deposed, so the other side is going to question them and ask them a bunch of information. Before they ever do that, I meet with them and I discuss everything that I think could possibly be discussed in that deposition. That's just the way it goes. That's what any competent attorney would do. So, and any expert, professional, competent deponent would not go in unless they've had that briefing. So I would bet, notwithstanding that, whatever the language is, on the 12th, when Gensler went before Congress, that he had already been briefed in detail, not only by Mr. Asher Taylor and others, but probably by general counsel of the SEC. And that, because somebody, a lawyer generally would be the one along with others that would be handling the preparation for the deposition. So I believe in detail that he would have done it anyway. But here, so let's put that aside. But here, we also have in this letter that he's referencing on September 5th that there's a briefing that happened. So I would find it hard to believe that subsequent to that briefing, when they were discussing and relating what had happened at the sessions briefing, that what they disclosed was discussed. So in essence, he was given the briefing by what they were telling him about what happened at the sessions briefing. Alternatively, and likely, that they would have discussed this before they went to sessions, and he would have signed off on it, or general counsel would have signed off on it, and then general counsel would have discussed it with him. But I find it hard to believe, in light of this, that he wouldn't have known. And in light of this new letter that we wouldn't have had access to, but for the disclosure, we wouldn't have known all of these meetings, the staff meetings, etc. And we wouldn't have known that there's no way that, even though I know that he had to be briefed, this gives us evidence of that further, and not on the actual briefing to sessions, but either before or after, kind of communicating about that. So what's the relevance of that? And I know that there was questions about defamation, because I think, and I didn't see the words. I haven't seen the words, because one of the things I was going to ask for, I didn't see the testimony. I think I listened to it, the testimony of Gensler, but I didn't see the transcript. So it really depends on specifically what he said and how he said it. You certainly could bring him back, you could subpoena him, and you could question him about that and what he knew and why he said what, if there was a relevant proceeding. But I know people were concerned about defamation claims. Same kind of issue would be, I think I saw some tweet where John Berta and George Palikaris were, I think it was John Berta in particular, was talking about Ralph Norman making some accusations about Palikaris and Berta having either generated or stolen or something, some amount of money, some large amount of money. I never heard the specific language. What's kind of difficult is you have to prove damages, and sometimes damages, specific damages, even though you would think that they're easy, they're not. And if someone's a public figure, it has to be with malice. And what's malice? That means like actively and intentionally making false statements. But what happens if somebody gives you a statement and they believe it to be true and you rely upon that statement? I'm not talking about Berta or Palikaris, but what happens if, for example, Ralph Norman gets the information from Mr. X, and Mr. X misunderstands something or is wrong, whatever. So there's a lot of reasons why they're difficult to prove, and as a result, defamation cases aren't often won. It's not saying, I'm not discouraging anyone from not pursuing defamation cases. I'm just stating as just a general rule, especially if the figure, like if these guys were considered public figures, because that has to be determined also. But if you're a public figure, it makes it even harder to win a defamation case. So even if they said stuff that's false, it may not be, practicalities easy to win. Oftentimes people retract statements, but whatever. I got sued for defamation in the Alpine matter. I made certain very kind of, well, they proved out to be, I would say, more than accurate. But I got sued, got out early. The case was dismissed. But I'm not discouraging anybody from bringing anything. But what's the relevance of that as to this letter? Oh, there was one other thing that caught my attention in the documents. And again, I looked through them, but I haven't really studied them. There's a letter dated the 20th, or there's an email dated June 25th of 2024 from Kevin Burris, who's with the SEC, to Merlene Darcy, who's with, she's the legislative director for Ralph Norman. And they're talking about they're going to have coffee, whatever. Apparently Burris wanted to have coffee with her. But she didn't get back to him. And then there's some information that came out that I guess Berta and Palikaris got a Wells notice, or either indicted or not indicted, but some action, a legal action. They didn't get indicted. They got a Wells notice, and there was legal action that was instituted, and they say it here, June 25th. SEC charges metamaterials and former CEOs with market manipulation, etc. So on June 25th, it comes out, and Darcy's reaction is, this is, and this is well into it. This is June 24. So the MMTLP crowd have been bitching about this now for 2 years. After Norman's office, after a bunch of other representatives, some of them may be gone after the prior election. And Darcy is Norman's legislative director. And I guess Norman, Berta claims, made false statements on Dan Ball's show, I think. I don't know. I didn't hear him. But I think that's kind of somewhat the issue. And her response at that time is, this is very welcome news. Thanks for the update. I'm already getting questions from congressional staff about a potential briefing. So she almost seems gleeful that there's been charges as opposed to retail getting any type of resolution. And I know by that time, even though it wasn't me, I'd heard plenty of it. By that time, Norman's office had heard a lot about MMTLP. So it's almost like she didn't give a shit about retail shareholders. This is just my interpretation. She just wanted it done. And if they could cast it aside without having to make any real analysis and really discover the real share count, for example, and settle the transaction, she was happy. And those words really pissed me off, to be honest. I think completely how is that good news? How is that welcome news? Who is that welcome news? The only thing that's welcome news is somebody who's lazy ass who doesn't want to do their job. Other than that, I don't see. And then how did they transmit that after that? So June 25th, 2024, when Congress kind of slightly went cold, did somebody from Norman's office then communicate this, or was somebody else in the SEC? And did they just assume, kind of contrary to my very first point, that this somehow had something to do with the U3 halt? Because it has nothing to do with the U3 halt or share count. Zero. So it would be interesting for me if additional legal action is taken, whether she can testify and what she can say. And I'm going to get to that last and not least. But it pissed me off when I saw that, her gleeful response. One, it's kind of what I talk about when I see these tweets and somebody, or like, Gasparino, he puts a tweet out and he's gleeful about some stuff in which retail traders have been harmed on MMTLP. He's gleeful in his position. And that really pisses me off when somebody gets glee in somebody else's misery. And this kind of fits that. This is in my opinion, I've never met the person. If you welcome that news, then you're a miserable human being. My own personal opinion. So what does this all kind of mean? And again, we're going to discuss this on Monday night, because this is kind of me at first blush, kind of looking at this stuff and kind of start rolling around things in my head. And there's a lot of space in there, not much up there, but a lot of space. So I can even hear the marbles rolling on. So I kind of went to the next stage, I thought. So let's say, so what's the issue here? One, is the SEC actually supervising FINRA? Isn't that their job? Because I know Congress isn't doing it. And that relates in part to, can Congress delegate responsibilities? And we know they did to the SEC to protect investors. If the SEC is not supervising FINRA, then are they really protecting investors? Are they really standing up to their duty? And if they're not standing up to their duty, does that impose any liability on them for that misconduct? So, we've talking about immunity before, and some of immunity is absolute. Like we've talked about FINRA, absolute immunity, so you can't go after them. And that's one thing we want to change. We, being the community, want to change. And we've talked about the SEC having immunity, but there were some holes for it, like the Administrative Procedures Act, and there's basic constitutional provisions, but there's also something called the Federal Tort Claims Act, and that allows individuals to sue the United States government for certain torts, and torts are wrongs. If someone, for example, if you're driving your car and somebody hits you from behind in their car, not intentionally, that would be negligence, and negligence would be a tort and a wrong, and you'd be entitled to seek, damages for that if in fact you really got hurt. I know Sammy JR's pig has been involved in a lot of accidents. I think some of them, in my mind, questionable, but you're gonna have to ask JR about them. But this statute gives people the right to sue the government. And, when I say the government, it could be from an agency of the government. So, and there's certain things you must do. There's certain jurisdictional requirements. So you have to kind of exhaust your remedies, whatever. But then once you get there, you could file a lawsuit. And, there's certain elements of the lawsuit that you'd have to file. And there's a 2-year statute of limitations on the lawsuit from when the conduct occurred. So there's a lot of issues to be thought. One is, are there damages, and when the damages happen? So looking, for example, the documents we got recently, does that give us information that we didn't have before that now gives us new claims and new damages? Did we know, since we know now that Gensler perhaps did not testify, because we have to see the transcript to see the precise testimony, but at best was evasive, if we had known the information we had known now, would the questioning have been different? Would we have had access to documents we didn't have now? Did we suffer damages by his very testimony, and him kind of minimizing and kind of poo-pooing the claims in respect to us shareholders? Did we suffer harm by that? Did it delay us from coming to an alternative? Is it a loss of use of money and damage for that? Are we entitled to emotional distress damages? Are they appropriate under the Federal Tort Claims Acts for these type of claims? Were they acting within the scope of their employment? I think so too. Some intentional acts are excluded. We'd have to show causation, which would be difficult. Again, you have to tie the misconduct to our damages. And now we're not talking about the actions of FINRA, we're talking about the actions of the SEC with regard to FINRA. And again, I think the testimony of Gary Gensler and his lack of understanding of MMTLP after being briefed and in light of these documents might suggest that the SEC did not properly supervise the FINRA, and it impacted us, and it was only disclosed by these documents reflecting what Gensler knew and could have done at that time. But again, these are very rough thoughts. I have not really thought them through, other than when I saw those documents, I thought about the exceptions. So what's the relevance of that? If in fact a lawsuit was filed under the Federal Tort Claims Act, then you could withstand a motion to dismiss, then you would have discovery, open discovery, and you could theoretically, depose Gary Gensler about his testimony. You could talk to Taylor Asher. You could talk to our friend Darcy. You could talk to all these people. They would theoretically be subject to discovery. And would that provide access to documents that might be helpful for concluding the MMTLP situation? Perhaps. Might it make some people, more cooperative? Perhaps. I think it would not be an easy journey. Lawsuit would have to be filed, get a lot of pushback. You might lose early. It might take appeals, but obviously it's something that I am considering and will think about, and I'm going to discuss with JR, et cetera. And I think, we're going to try to see if we can come up with some claim that might have the ability to work and provide potential access. If this is not our forte. We haven't had a lot of FOIA litigation. Obviously, there's probably very little FOIA litigation, unfortunately. But it's kind of be kind of this way. And JR and Sammy the pig really don't know this yet. But if in fact we can find some basis, then we're going to see what we can do about filing something. If, however, we don't think there really is a basis for filing an action, as we try to do always, we'll be open and honest about that. That won't change whether he knew or didn't know something. And that also might not change any action that might get, any current action that's pending. Might these documents open the door to depositions? If we get far enough, if someone gets past motion to dismiss in the discovery stage, does that open the door? Does that open the door for more discovery? And also, cases, I'm wondering about the cases like, Northwest Bio, for example. I've heard of that one that was heavily shorted. And they have just made it through a motion to dismiss. And I don't know their story, but my guess is they've probably complained to the SEC and FINRA multiple times. And if they're involved in litigation, in light of these documents and perhaps the lack of care that the SEC has taken, be interesting to see if they would try to take the depositions of the former personnel of the SEC and to find out what was going on. It might be interesting for, to have a mass inquiry of what was going on. And new administration, the new head, Paul Atkins, again, has an opportunity, a golden opportunity to kind of set himself aside from the prior regulatory body. So when I thought about the Tort Claims Act, I thought, wow, is that going to open up discovery? Could that allow for depositions of key people? Might that allow you to depose Gensler and others in high places? Might it give you access to FINRA personnel? Might it give you access to FINRA documents? Might it give you access to documents that might help you? Again, just off the top of the head, I think this will, after we have a chance to kind of ruminate on it and think about it in a little more depth, I'm sure there will be a lot of additional thoughts that come in. Again, on Monday night, I'm doing a live stream with Curtis and JR, and we're going to be going over these documents. And we haven't discussed these at all, other than the fact arranged the live stream, but we haven't discussed them at all. So whatever they come with, I'm sure will be different than whatever I just said. And Curtis may have more of an internal view as to what's going on back east as to this stuff. And I know JR had prior involvement in that too. So it'll be interesting to go on. But those kind of were the four things I wanted to talk about. So it was DJT and kind of their reasons for what their concerns and the alert they point out, and the fact that the short was an out of country short that wasn't apparently reported. And that's MMTLP, and probably, my guess, this is all guessing, every unlawfully shorted stock that exists on the planet probably has shares that left the country just that aren't counted, and that FINRA says, tough, we can't count them, so they don't exist. Unacceptable. And then we talked a little bit about MMTLP in general, how it, that Devin Nunes, I know, is aware of it, and aware of other tickers that they are going to, I think, at this point in time, it appears they're going to pursue it. I don't know that firsthand, just from what I hear from multiple people. And then we talked about the FOIA, and the whole FOIA process is being FOI, not FOIA, because there should be some centralized software where the public since it's our information, can go and pull it. And if we want to pay for copies, we can pay a reasonable price for copies. And if there's issues about redactions, that's fine, but it can't be that you have to go to court, because that makes it basically inaccessible. And that's not what it's designed for. It's designed to give us access. And then we looked at, so we talked about that. And then we looked at the documents, or some of the documents that came through that George Palikaris posted. And I referenced the kind of couple things that concerned me. One, that when Gensler appeared in Congress, he would have been briefed by counsel and who are staff anyway. And then two, the letter dated September 25th suggests that that briefing that was given to Sessions would either have been given to Gensler before or after the meeting with Gensler. So it would have been like a double shot that I believe he was clearly informed of the consequences. But I need to see the transcript to know if his testimony is technically false. It certainly was deceptive, but that would be a different issue. And then we talked about perhaps, defamation, and it's difficult to bring because of the malice requirement, and because you might get the information from a third party, and because damages are often difficult to prove because it has to be relative to the position of the person. And there may be strategic reasons also from a legal standpoint, if you're sued, why you wouldn't want to do that. And then we talked about the Tort Claims Act and whether that would give potentially MMTLP shareholders access to claims against the government individually, that there's a 2-year statute of limitations, but perhaps these new documents and the fact that Gensler either was wasn't not competent, or was deceptive or false, might restart the statute of limitations. And then there were other issues about damages, etc. And all this has to be explored. But this is all new, and I expect DJT to push. And I think the short market is going to be very interesting, because I think at some point in time, if in fact there still are shorts, and if in fact there's illicit shorts, and if in fact those illicit shorts can escape their positions, and if in fact they really think there's either going to be some kind of short sale ban or actual action against them, then I would expect to see activity where there's a lot of short covering that. That'll be interesting to see if that actually happens. I wouldn't think it would actually happen or start to happen until Atkins gets officially posted as the head. And I expect that to be any day soon. So I'm interested in see what the market looks like after everybody believes that the shorts are going to be treated differently. Now, if in fact they aren't treated differently, then you're going to get another video from me pissed off and talking about some regulator or somebody not doing their gig. Because, in this case, I really don't care the motivation. I don't. So if in fact that the motivation of the administration is to personally benefit their DJT by going after shorts, I'm perfectly fine with that, because everybody else will benefit, even if it's done out of self-interest completely. If in fact they tackle the shorts, then I'm all for it. That's kind of like my belief in a lot of things. If the ultimate outcome is super beneficial to everyone, then I have a lot more leverage for the person. That would include also like people who give large amounts of charity. I don't really care the reason, even if it's, some bad reason. If they're giving like, tens of $millions to the Children's Hospital out of guilt for having taken 3 apples when they were 7 years old, then so be it. I'll take it. So I don't really care the reason, even if it's just for DJT. I think taking aggressive action at DJT will benefit all short shareholders. And I didn't think Devin Nunes was going to sit calmly and wait for that. So I expect him to go after this with vigor, and I expect it soon. So that's what I'm looking forward to. Anyway, hope that's all I have to meander about. Please join us Monday night, where you'll get a different view on many of these issues. Also, I'll be talking about GTI this week, because I expect to have an update, factual update about activities that are going on since the last update. to bring everybody up to speed. I don't know exactly when, but I will, as soon as I know, I will let you know. I'm expecting to speak to our counsel early in the week. As soon as I get a update from our counsel, I will let everybody know what's going on. And other than that, I hope everybody's well. Have a happy holiday. Be well. Take care. If you have questions, put them in the comments section when you see it. Appreciate everybody out there. Take care. Have a great